I've received a copy of a parole board decision dated September 24th of this year. They intend to reinstate your parole this November. And they find, quote, reasonable assurance exists that the offender will not become a menace to society or to the public safety. I mean, I don't want to stray too far out of my lane and talk about the parole process, but come on. I could not disagree any more with that statement. I think it makes a mockery of the criminal justice system. I don't even know what words in the English language mean. If you can say those words about this offender at this time, reasonable assurance exists that Mr. Page will not be a menace to society or public safety. How about he drives drunk whether he's on probation or parole? How about he commits felony crimes even while he's in prison? I'd like to know what the parole board thinks is a menace to society. I think it might be Mr. Page.
What I think is most important to highlight today is that Mr. Page stands before you today ready, willing, and able to tackle his substance abuse issues. With the grace of this court, Mr. Page hopes that you'll allow him that opportunity. Mr. Page realizes that you've heard that before, and that those words are often hollow. He is sincere, and his actions since this last offense show that he's ready to start his journey towards recovery. The people closest to Mr. Page have also reported that his genuine efforts, that he's made genuine efforts at becoming a changed man. His conduct while he's been incarcerated has been exemplary. He's had no write-ups. He's engaged in the services that are available to him in the jail. For long-term sobriety, this needs to continue. That's why we're asking for the jail sentence followed by inpatient rehab at KPEP and then followed by a term of probation with alcohol monitoring. Thank you, Your Honor.
Thank you, Ms. Elliott. Mr. Page, you don't have to say anything today, but it is allowed. Is there anything you want to tell me or no?
Yes, Your Honor, I do.
Okay, go ahead.
Your Honor, I did prepare a speech and I was going to give it today, but my lawyer took a copy and gave it to you so you may read it on your behalf.
I already did.
Yes, Your Honor. I understand that people come in here every day and they try to explain to you that they're trying to get sober and they're trying to live their life better, but I really truly am. And I understand that my past does not reflect that whatsoever. But I truly am ready to quit. I've been going to AA every month or every Monday morning that I can, and I'm really just trying to get help. And I'm honestly so ready to get sober, and I want it and I need it. And I understand that there's a big lengthy prison sentence in front of me. And I've done 6 years in prison, Your Honor, and it just does not help me. I have a lot of trauma to deal with, and I really am ready to face and handle these problems. And you know, it's just it's hard for me to sit here and convey to you who I am as a person because my past does not reflect a very good thing. And all I'm asking is, please, Your Honor, to just give me a crown year and to offer me KPEP at the end of it and probation and the ankle monitoring. If I screw up, you already know you can give me a lot of time. You know, I know I'm facing that right now, and I know I've had a lot of chances. I'm just asking you, please, this one time, just give me one more chance. Please, Your Honor. And that's all I have to say, and thank you very much.
All right, thank you, Mr. Page. Ms. Goodrich, recommendations from the people?
Oh, yes, Your Honor, thank you. The defendant is 31 years old. It looks like his first arrest was at 14 years old. He has 5 prior felonies, 5 prior misdemeanors. There's a public safety concern on the type of felonies on his record, accosting a minor, breaking and entering, multiple weapon charges. He's been placed on probation 4 times, jail 5 times. He's been to prison 3 times. Services have been provided prior to this. He was on parole when he committed this offense. It looks like from the PSI that he has a history of MDOC misconducts, approximately 24 total. He initially was on parole on August 1st of 2023. It looks like in June 29th of 2024, he operated a vehicle under the influence, also had drug paraphernalia and weapons. On November 14th of 2024, he was on parole and was reinstated with a scram. On June 17th of 2025, while on parole, the defendant operated a vehicle with an expired registration plate. He refused the PBT. He had empty whiskey bottles, multiple, found in his car. The cup next to him had alcohol in it. The lab blood result came back at a 0.195. He completed a substance abuse assessment back on January 3rd of 2024, but did not follow through on any of the recommendations. His guidelines are 10 to 28 months. The PSI, I believe, appropriately recommends the 28 months to 70 or 6 months. The top of the guidelines is appropriate in this case based on his decisions in his past. when he's released from this prison term on parole this next time, I hope he does use that support system that he has available and takes advantage of having that benefit, as well as the substance abuse services in our community. Thank you.
All right, thank you. Mr. Page, if you please stand for the first sentence. There are, yeah, I know Mr. Page has acknowledged his prior record not being his best foot forward, so to speak. It is important that on the record we place some of those things. So some of the relevant factors that I've looked at here, back in November of 2014, Mr. Page was sentenced for a felony breaking and entering. He got probation with 6 months upfront jail and the SAI boot camp. And then in 2015, he violated probation by drunk driving with a high BAC. He got 6 months more in jail, but probation was continued. So he got chances to address that, 10 years ago. In 2017, he violated that probation again by stealing a gun. He went to prison for that, for 28 months on stealing the gun and 4 years on the probation violation. While he was in prison in 2018, he committed another felony by possessing a weapon in prison. He got another 14 months in prison for that. Then while he's still in prison in 2020, he commits another felony, prisoner possessing contraband, and he got another 14 months consecutive prison for that. So that's why then the prosecutor says he went to prison 3 times. It was really 1 time he went, but you had 3 commitments, 3 sentences. So that's when he did the 6 years. And it's, reported in the PSI and also in the defense sentencing memoranda that, you had some really negative experience that had happened to you or around you while in prison. And, that's regrettable and that should not happen. That's not what anybody intends to happen. That's not part of the punishment of a sentence. Prison should be a safe environment for people, but the reality of human behavior makes it such that sometimes it's not. So I regret that you had to witness some of those things. You were granted parole on August 1st of 2023. The next summer, July of 2024, you were arrested for drunk driving on parole and a CCW, a carry concealed weapon charge. In that case, there was a BOL, be on the lookout for someone driving crazy. You were twice the legal limit, had a fixed blade knife in the visor of the car. That November, I dismissed the CCW charge, finding that there was not legal basis for that charge. But it did qualify as a violation of parole, possessing any weapon at all. But I dismissed that felony charge and granted you a PR bond. And then the DOC lifted the parole hold and reinstated your parole. Again, giving you chances to address these issues. You responded by tampering with your alcohol scram tether in early December. And then in December, I sentenced you, you pled and were sentenced to the misdemeanor OWI. You'd already served the maximum time, so we cut you loose at that time. And your parole was reinstated, continued. And then this May, while you were still on that parole, you were again arrested for a OWI 0.19 BAC. In addition to the 2 felonies committed while Mr. Page was in prison, he had several misconducts in prison, including using alcohol 3 times, using other substances 3 times, fighting 3 times, possessing stolen property 3 times. So, you were kind of contributing to some of the bad environments and behaviors in prison as well. There's a pattern of drunk driving here in 2015, 2024, and 2025. All 3 of those drunk drivings involved a BAC of more than twice the legal limit. All 3 of those were committed while Mr. Page was on some form of supervision, probation, parole, and parole. And this is the second OWI committed on the same term of parole. Despite all of this, and Mr. Page says that now in May, since May of 2025, Now he wants to get sober. I mean, there's been more than a decade of efforts and opportunities for you to get sober. Instead, you drank and used in prison. You drove drunk while on probation. You drove drunk while on parole. I mean, I hope and wish what you're telling me today is true, but how on earth can I accept that as true? I mean, how could you reasonably expect a judge to say, oh, now Mr. Page says he gets it? That's just not, there are ways that this works. And that is just not how it does. I've received a copy of a parole board decision dated September 24th of this year. They intend to reinstate your parole this November. And they find, quote, reasonable assurance exists that the offender will not become a menace to society or to the public safety. I mean, I don't want to stray too far out of my lane and talk about the parole process, but come on. I could not disagree any more with that statement. I think it makes a mockery of the criminal justice system. I don't even know what words in the English language mean. If you can say those words about this offender at this time, reasonable assurance exists that Mr. Page will not be a menace to society or public safety. How about he drives drunk whether he's on probation or parole? How about he commits felony crimes even while he's in prison? I'd like to know what the parole board thinks is a menace to society. I think it might be Mr. Page. And all of that doesn't even take into account that he's a registered sex offender. I have to say, I think the advisory guidelines of 10 to 28 months do not adequately take into account three factors. First, defendant's profound pattern of criminal behavior, even while in custody and even while on supervision. Second, defendant's pattern of driving at more than twice the legal limit every time he drives drunk, even while under supervision. And third, the fact that he's twice driven drunk since he's been paroled in August of 2023, yet the Michigan Department of Corrections doesn't believe that behavior is enough to return him to prison on his parole. So honestly, I think an upward departure from the guidelines is warranted in this case, given that this is this defendant's sixth felony, his third drunk driving, two that he's been paroled. He continues to possess weapons inside prison and while on parole. Even though I dismissed the charge, he was possessing weapons on parole. It's clear that this defendant poses a danger to society. You know, I regret, Mr. Page, to tell you, I think a maximal sentence is proportionate here. The law limits what I can do to 2/3 of the maximum, which means the highest sentence that I can impose would be 60 to 90 months in prison, or 5 years to 7.5 years. I believe, given the history I've outlined, given his behavior while on parole, his behavior the last 2 years while on parole in our community, the last year, I believe that a minimum term of 5 years in prison is certainly a proportionate sentence, given the seriousness of the circumstances of both this offense and this offender. Such a sentence, I believe, to be more proportionate than a sentence within the advisory guidelines range. Therefore, Mr. Page, I am going to commit you to the Michigan Department of Corrections for not less than 5 years, nor more than 7.5 years, exercising my discretion under the habitual offender statute to increase the statutory maximum. That's mandatory consecutive to parole, so there's no jail credit given because you've been on a parole detainer. There's $68 in state cost, $130 in the crime victims assessment, $350 in court costs, and a $200 OWI reimbursement. You can, and you know, from what I outlined about what happens in prison, what you've seen, what you've done, there are choices you can make in prison too. And you can begin to address these issues in prison. And I hope you make better choices on the inside this time. And when you are paroled, you're still going to be paroled as a fairly young man. You'll still have choices to make when you're paroled next time. So I hope that half of what you're telling me today is true, and that you'll be on a better path, and this will be the last commitment you get to prison. But I think given that history, you should expect judges to give you the maximum that they can. I think that's just what's reasonable. Mr. Page, if you want to appeal, you can do so by filing an application to the Court of Appeals. If you want a lawyer, I would give you one, but you'd have to ask me within 6 months. We're going to hand you a piece of paper explaining that. Ask you to initial one for us. The other one's for you to fill out if you want to take an appeal. And good luck to you, sir.
Thank you.
Here is your closing VO. This was a sentencing hearing that laid out in painstaking, methodical detail what happens when a system repeatedly extends grace to someone who repeatedly refuses to meet it halfway. Mr. Page, 31 years old, stood before the court for his 6th felony conviction, drunk driving, at nearly twice the legal limit while already on parole. His record stretches back to age 14, 5 prior felonies, 5 prior misdemeanors, probation 4 times, prison 3 times, and yet each time supervision was reinstated, each time a charge was dismissed, each time a second chance was granted, the pattern repeated itself. Drunk driving in 2015. Drunk driving in 24. Drunk driving in 2024. Drunk driving in 2025. Every single time, more than twice the legal limit. Every single time, while under some form of court supervision, his attorney made a sincere plea. Mr. Page himself made a sincere plea: 1 year, KPP inpatient rehab, probation, ankle monitoring, just one more chance. His words were emotional and by all appearances, genuine, but the judge had heard the words before, and the record spoke louder. The court departed upward from the sentencing guidelines and imposed the maximum allowable 5 to 7.5 years in Michigan Department of Corrections consecutive to parole. The judge didn't hide his frustration with a parole board that had just weeks earlier declared that reasonable assurance existed. Mr. Page posed no public safety risk. The judge called it plainly a mockery of the system. There are no villains in this story. There is a man battling addiction who ran out of chances, and a judge who still closed the door with a word of genuine hope for what comes next. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns, because justice never gets old.